Hi, good afternoon. Today is Thursday, September 15th. My name is Ashley Glover. I'm here with attorneys Kim Christian and Diana Lattanzio, and we are happy to welcome you to our webinar, How Do I Protect My Minor Child with Special Needs? Thank you for joining us. Before we start, I do have just a few brief housekeeping notes. To help minimize background noise, we have muted your microphones. You'll want to use the Q&A box to submit your questions. We do have time reserved at the end to answer as many as we can. This presentation is a half hour. We are recording and we'll email you a link to the video. Let us know how we did in the survey, please. And if you need to message me about anything, you may do so in the chat box. All right, let's move on and get to know our presenters, and we'll start with Kim Christian. Kim is a dedicated partner at Russo Law Group. She's been with the firm for over 15 years, helping clients with elder law, special needs, estate, and trust planning. She's the lead planning attorney in our Lido Beach office and is a member of several bar and board memberships. Diana Lattanzio brings 20 years of experience to Russo Law Group, where she focuses on elder law, Medicaid planning, estate planning, real estate, and special needs. She is the lead planning attorney in the Garden City office. Diana is admitted to both the New York State Bar and the New Jersey State Bar Association. So, Kim and Diana, thank you so much for being here and putting this whole thing together. Kim, are you walking us through the agenda today?
Yes, thank you. And we're happy to be here. And let's get started. So what we will cover today, we're going to start out with the parent's estate plan. So whenever we're planning for a child with special needs, we want to make sure we have our estate plan in order. So we're going to start with what we think a parent would need or parents would need. And we're going to focus on a vehicle that we find to be very important in this arena, a third-party supplemental needs trust. Then we're going to move into maximizing benefits. We know that that is an integral part of this kind of planning. So we're going to talk about that. And then we're going to move for planning for your child as an individual and what, if anything, you need to be thinking about as far as preparation for them. And if we have time, we're happy to answer any questions and we'll have a Q&A session. If not, we are absolutely here to be a resource for you if you have any follow-up questions. So as I mentioned, we're going to start with the parent's estate plan. And as I mentioned earlier, a third-party supplemental needs trust is a very useful vehicle, legal vehicle that you may use when implementing a plan. So I'm going to pass the torch to Diana, and she's going to speak to you a little bit about this.
Thank you, Kim. So parents of disabled children sometimes mistakenly believe that the best thing to do is to exclude or disinherit their disabled children from their estate plans. I often hear that they will name a family member or a friend as a beneficiary to informally hold the funds and rely on them to provide for the child. And I would say that this is very, very risky. There is no guarantee that your wishes will be fulfilled or that the funds will be used as you had intended. So a better approach is to properly plan to provide your assets and income to supplement your child's needs, even when you're gone. And that would be done by virtue of a supplemental needs trust. This is a special type of a trust that protects your assets from a payback to any governmental agencies that may be providing services to your child. In addition, it allows your child to still qualify and maintain his or her current benefits, such as SSI, Medicaid, or SNAP. There are different types of supplemental needs trusts that we will discuss. When a parent creates one and funds it with the parent's assets or someone other than the child's assets, it is referred to as a third-party trust. This trust can be revocable, which means it can be amended or terminated by the parent at any time, or irrevocable, which basically means it's much more difficult to change or amend the terms. The trust can be either an inter vivos trust, which means it is created and funded during the parent's lifetime, or testamentary, which means it's created and funded upon the parent's death through a document called a last will and testament. The trust can be funded with the parent's assets, such as real estate, a house, liquid assets, such as bank accounts, life insurance policies, or retirement income. Planning with retirement accounts has become more complex due to the enactment of the Secure Act of 2020, which drastically changed the required minimum distribution rules. If you're considering naming your disabled child as a beneficiary of any qualified assets, such as an IRA, 401k, 403b, deferred compensation, it should only be done through the creation of what we refer to as a secure SNT, or secure supplemental needs trust. This type of trust has special tax provisions which would allow the disabled beneficiary to stretch the required distributions over his or her lifetime to limit the income source in order to maintain their current government benefits.
So I'm gonna actually take the next slide as part of what Diana was talking about. So now Diana focused specifically on a supplemental needs trust, which, as I said early, is often an integral part of a parent's estate plan. But there's something that I always say. I always say, if you want to protect your child, the best way to protect them is also to protect you, and to give people the ability to assist you in the event you need that kind of assistance. So the next slide is about what's called advanced directives. Advanced directives are documents that I do in advance of any sort of incapacity or declining capacity that says, if I need assistance with finances or I need assistance with healthcare, these are the people that I trust and I'm going to put in place to make those decisions for me. That way I can feel comfortable that the world that I am living in will continue to operate from a financial and healthcare perspective, because I've nominated individuals that I trust and can take over in that capacity. So the first document is something called a power of attorney. We recommend a durable power of attorney. A durable power of attorney is a document that says, I am going to nominate an individual or individuals that I trust to step in my shoes and make financial decisions for me if I need or want them to. And this is important because if I even have a temporary incapacity or a permanent incapacity, I certainly want to make sure that the person I trust is making financial decisions for me, paying my bills, setting up that supplemental needs trust for my child if necessary. Things of that nature that are very important. As for the healthcare proxy, that has to do with healthcare decisions, from the smallest decision all the way to the biggest end of life decision. And it's critical that I have someone there to be making sure the best decisions could be made regarding my health. The living will is a document about end of life decision making. It puts instructions as to what I would want during an end of life situation. For example, if I'm in a permanent persistent vegetative state, this document may say, at that point, I do not want any extraordinary means. It's critical that we be as clear as possible. That way we can help those that are in our world and continue to be. Last but not least, we want to make sure that we have a HIPAA authorization. That way our healthcare proxy can access our medical records, speak to our healthcare professionals, never making a decision in a vacuum. So while Diana spoke of a very important planning tool, which is a first-party supplemental needs trust, I also wanted to add this component because I do believe that making sure your world continues in the manner that you would want it to if you were to have a short incapacity or, frankly, a long one, you had the person that you trusted to make those decisions for you. So I'm just going to do a quick summary of our first session. We did planning for the parents. What you want to do is you want to get an estate plan in place. I'm going to start a little out of order on this screen. I'm going to start with advanced directives. Those matter while you're alive. So you just want to be making sure someone can make those financial or healthcare decisions for you. Now, in the umbrella of estate planning, since we are talking about planning for a child with special needs, Diana highlighted something called a third-party trust or a supplemental needs trust. And what she shared with you is it can be what's called testamentary. So I can have my will say, I leave everything to my child subject to the trust under Article 5, for example. And that is a way to have your will direct your child's share into a trust that will remain protected for that child and not disrupt any benefits that they're receiving or attempting to get. Diana also mentioned something called a living trust, which is distinct from a testamentary trust. So a testamentary trust is a trust that is set up upon my passing. A living trust is a trust that's set up during my lifetime. And Diana said, you know what? There's people out there that might want to leave my child or give my child a gift in their lifetime, a birthday gift, for example, or for example, grandma and grandpa might want to leave an inheritance. And we want to have a vehicle in place, a third-party trust that can accept those monies, whether it be a gift, whether it be an inheritance. We just want to make sure that we've got this trust for the benefit of your child to make sure that it's held in a protective way so it doesn't disrupt any benefits, and it allows them to move forward in the event they are looking to get benefits. So in sum, we talked about a testamentary plan that may leave assets in a supplemental needs trust, also known as a third-party trust to my child. We also talked about a living trust that allows it to fund during lifetime to protect my child. And then, of course, we talked about the advanced directives, making sure that we designate in advance someone to assist us with our healthcare and finances in the event we need them to. All right, so we're going to move to maximizing government benefits, also a very critical component to planning for your child with special needs. All right, so let's talk about SSI and Medicaid for your child. So when we discuss accessing benefits that may be beneficial to your child, we have to keep in mind a few things. Many of these programs are financially means tested, which means they are allowed to have limited assets and income. And we're going to dive a little bit into the specifics in a moment, but really overarching theme is if we are going for a benefit that is financially means tested, then we have to make sure that we don't have too much income and we don't have too many assets. And if we do, we have to come up with a plan to address it. Because if we have too much income or we have too much assets, it may knock us out of the box for certain government benefits that would be very beneficial and very helpful for our child. So for example, there is a benefit called SSI. SSI is a financially means tested program that says my child may not have assets more than $2,000 in their name. And what the Social Security Administration says is if your child did have assets of more than $2,000 in their name, and then you move those assets, there is the potential that if you did it within 3 years, that we're going to penalize you. So it's important to be discussing with your attorney, what, if anything, you need to be doing to get your child eligible. I call it the shoebox example, right? You know, everybody was so kind and so generous at my son's first birthday, and they gave us all these bonds and we held them in the shoebox in the closet. And now we're looking to get SSI and we have an issue because it's certainly worth over $2,000. So what, if anything, are we going to have to do? So what this slide is about is just preparing us, making sure we understand that many of these benefits are financially means tested, and you should seek the advice to make sure that you're planning in the appropriate manner so that if you do want to access these benefits, you're ready. So there's a third component on this slide, and it's called parental deeming stops. So what is parental deeming? It's important to understand that prior to the age of 18, right, SSI is a means tested program, but the parent's income is deemed as part of the child's. So we can say to ourselves, well, of course, my child is 7 years old. He or she doesn't have any income. But because they're under the age of 18, the parent's income will be deemed as part of their child's. So it's important, again, to discuss this aspect to make sure what, if anything, needs to be done, what are the eligibility rules, and how do I address that? The same goes for parental deeming for Medicaid. We may be accessing the Medicaid system because there are a lot of excellent benefits that go along with it. But it's important to remember that parental deeming does not stop until your child reaches age 21. Where will my child live? This is a very common question that my families ask me all the time. They're thinking prospectively. As my child gets older, if something happens to me, where are they going to live? What are the options, Kim? Where should we be looking? What should we be thinking about? So there's a couple of options. One, you want to identify whether you believe your child can live independently. And that is possible. We always encourage independence if possible. And a lot of times, some of my families will say, well, they'll end up living independently with supportive services. And that's a really important piece of this because there are supportive services out there that you can reach out to. You can have an aide in the house sometimes. You can have certain life skill components come in. So it's important to discuss with your attorney, what are my different options? Sometimes my family members will live with an actual family member. They've made plans in advance for Johnny to go live with Sally, his sister. Sally has the capability, Sally has the wants, and Sally knows that she can also have supportive services in her home to help with her brother. Then, of course, we have a group residence option, right? Where we can have our child live in a group residence setting. But the most important thing is that we're thinking about this in advance. For example, we may be accessing OPWDD to make sure that we examine some of our options and open some of our doors when it comes to the options that there are for where your child is going to live.
Thank
All
you.
right. Right, I was just going to pass the torch to you, Diana. So we're going to move to more planning for the minor child. We're going to focus now on the child themselves and what we can do there. So take it away, Diana. Thank you.
Thank you. In this segment, we will discuss decision-making for your child when your child reaches the age of 18, and also different options for preserving his or her government benefits if there are excess resources or assets that the child owns. So while your child is a minor, which is under the age of 18 in New York, the parent has the right to make any medical decisions for the child or decisions over property. But once the minor child reaches the age of 18, the parent does not have the authority to do so anymore pursuant to the law. So one option would be, if your child does have mental capacity to execute advanced directives for him or herself, that would be the first option and the preferred option. It's the least restrictive means to having that child render an agent to make decisions going back to or reverting back to the parents. So the child can execute a durable power of attorney, naming the parents in charge of making any financial decisions, and also a healthcare proxy naming one of the parents as the primary agents and maybe the second parent as the successor agent to make medical decisions. and a living will, which would encompass end-of-life decisions. But that's only if the child has the capacity to do so. If the child does not have the capacity to execute any advance directives, then that would prompt the need for a court-appointed guardian. And there are basically two different types of guardianships in this instance. The most common is an Article 17A guardianship proceeding, which is commenced in the surrogate's court. It's the most common for parents of children with special needs. The person must be diagnosed as being mentally retarded or developmentally disabled. It would allow them, the parents, to continue to make medical and or financial decisions for the child, even after the child reaches the age of majority, which is 18. It's a friendly type of court proceeding, but nonetheless, it does require a petition, some comprehensive medical forms, a hearing in person, but the medical forms, basically the doctors need to be involved, psychiatrists, psychologists, and a medical doctor. And then the parents should also consider naming standby guardians to step in the event that the parents themselves become later incapacitated or pass away, so that it would avoid a secondary proceeding in that instance. But you shouldn't wait until the child turns 18 to start this proceeding, because there may be a major health decision that needs to be made immediately, and you're going to be really pressed for time. So we recommend at least a year prior, so when the child is 17 perhaps, to start considering starting this petition. And there's also a secondary petition that can also be commenced. That is called an Article 81 guardianship, and that is commenced in the Supreme Court. It's for people with functional limitations and diminished capacity, seeking very specifically tailored powers. So I would say 9 times out of 10, in a situation with a minor disabled child with the parents petitioning, we would normally commence that in surrogate's court under an Article 17A.
Okay, I'm going to jump back in. This is Kim again. Thank you, Diana, for that. That was also a very important segment. So it's important for us to be thinking prior to the age of 18, whether we think that we are going to petition for guardianship court, so we can make sure that we have the ability to make decisions for that child if necessary. So the next thing we're going to talk about is what I called before the shoebox example. So what if your child has assets in his or her name? And this is going to result in perhaps needing something called a special needs trust, a first party trust. And it's called a first party trust because it's set up with assets of the individual who is looking to obtain the means tested benefits. It's the actual first party, it's your child. So this kind of trust is going to protect the assets and the income or the income of the person who's disabled while also accessing government benefits. So I said earlier, for example, if I want to access SSI, my child cannot have assets more than $2,000. And if they do, then we want to consider setting up a special needs trust. Once we set up that trust, then we can fund it with the assets above the limit we're allowed to have. So if I'm allowed to have $2,000 and I have, I have $100,000, then I can put everything above the $2,000 into this trust. It has to be funded with assets of the actual individual who is disabled, and they must be under 65. One major distinction between a supplemental needs trust, which Diana started with and is funded with other people's money, is the trust I am talking about now. It has a payback to New York State for any Medicaid services that child had been given. So if I fund this trust, I get immediate eligibility for SSI and Medicaid. And it's critical I use this money for my child's quality of life, because way in the future, if there's any assets in that trust left over after the beneficiary passes, there will be a payback to New York State for services received from Medicaid. This trust must be irrevocable because Medicaid and SSI are looking to find out whether the child has retained too much control over it, and it really could be considered theirs. So in this instance, a special needs trust is going to be irrevocable. And of course, selecting a trustee is of paramount importance. And we're going to talk about that now. So selecting my trustee, and my slide indicates exactly how I feel. No decision is more important. This is the individual or entity that is going to be managing the money for your child and who is going to be paying for the things that they need for their life. So you might consider a family member, a friend. There's professionals out there. There's corporate trustees such as banks and trust companies, and there's also pooled trust. You just want to be making sure that the person that you pick as trustee understands your child's needs, understands the benefits they are on, and knows who to reach out to or are familiar with the rules regarding those benefits. All right, I'm going to pass this now back to Diana. We're going to end a little bit with pooled trust. So go ahead, Diana. Thank you.
Thank you, Kim. So another option, which is an alternative to a first-party special needs trust. So if you don't want to create that trust or have to select a trustee, then there is another option where the beneficiary can join what's called a pooled trust. Pooled meaning that it's not a private trust that is just holding that beneficiary's money. It is a lot of different persons that are in the similar situation, either over-resourced or have too much income, that join this type of a trust that is managed by a charity. There are 23 now that are approved in New York, and it can be either an asset trust for excess assets over the $2,000 or an income trust for an overage of monthly income. And it will still maintain the beneficiary's benefits for any government benefits. If the beneficiary is receiving SSI, then the funds in that trust cannot be used for food or shelter, but it would be okay for dental, vision, or supplemental aid care. The difference with this type of a trust is rather than the payback upon the beneficiary's death back to New York State, as Kim was discussing, the remainder actually goes to the charity that is sponsoring and monitoring this type of trust. And the trust assets are actually segregated from everyone else's, so it's not really pooled in together. The pool term just meaning that it's, different persons that all join this type of a trust or the master trust, but everyone's funds are kept separate and apart. We use the Teresa Foundation, which is an amazing charity that benefits special needs children on Long Island through summer camp, dance, and art programs. So we see a direct benefit, and it goes back to benefit special needs children on Long Island.
Thank you, Diana. So what do you do now? As you can see, it's so important to create a plan. You want to make sure your legal documents are comprehensive and up to date. And most importantly, you want to get it implemented. There is a lot of thought that goes into it. My parents are constantly thinking, how am I going to protect my child? And the best way to protect them is to get this plan implemented. As you can see from Diana and my presentation, there are intricacies to this kind of planning that are above and beyond. So you want to make sure that you just speak to an experienced planning attorney and you create that plan and you get it implemented. All right, so we are rounding out the half hour. I do not see any questions in the question and answer box, but we are available to be a resource to you. So you can feel free to email Ashley independently, and if we are able, or we will be able to reach out to you if you have any questions of us.
All right, this is Ashley. I'm going to step in and wrap us up here. So what makes Russo Law Group different? It's our clients tell us that it's our dedication, accessibility, scope of legal services, and years of experience that gives them the peace of mind and confidence when working with us. We will not learn at your expense. This firm has literally written the book on estate and elder law planning. We've helped over 17,000 families. We build a relationship with our clients. We truly care about you, and we want to be your attorneys for life. Here are the services that we provide and how we can help you and your family. I would urge, as Kim mentioned, anyone who has further questions to give us a call right now. We're happy to speak with you. And finally, I just want to appreciate everybody for joining us. I do see a couple, looks like some questions maybe popping up now, Kim.
Yeah, and I just showed my screen because I saw them, and we're at 1:31, but I'm happy to take a minute and just answer those questions. So the first one is, can you repeat the point about a pooled trust not being used for housing? So I believe that's a point Diana made. And what she was trying to say is, and this is all on a case-by-case basis, but in Diana's example, she was saying, be careful of what you use the assets in the first party trust, whether it be a pooled trust or a living, special needs trust, because if the child is on SSI, then giving a distribution or paying for certain housing components may reduce the child's SSI benefit in a substantial way. So I don't think it's necessarily case specific to a pooled trust, but it's a caution that says, hey, these rules are really intricate. And if your child is on SSI, for example, you just want to be making sure you're not stepping over that rule regarding housing. Diana, did I summarize that correctly?
You certainly did, and that's why it's so important to choose a proper trustee who would be well-versed in the benefits and what could be paid as a distribution and what could not.
All right. And then the second question is, to confirm, the special needs trust does have to pay back to the state. All right. So different practitioners sometimes use different words to note different kinds of trust. So you heard me correctly when I was speaking about a special needs trust. I did say there was a payback to the state. But it's important to understand that this special needs trust that I'm talking about is considered a first party trust. All right. And the first party trust is what has the payback. So in the context of this particular webinar, the term special needs trust is equated to a first party trust, which in fact does have a payback. All right, I think we covered them, right, Ashley?
Yep.
All right, so before we get off, and I just want to say thank you to all the attendees. I'm very grateful that you took the time out of your day to hear what we had to say. And, we're happy again to be a resource to you. And thank you, Ashley and Diana, for being my co-presenters.
Thank you.
Okay, and one last note, please leave us your feedback in the webinar survey. All three of us here are anxious to see your comments and responses. So Diana and Kim, thank you again, and everyone be well and stay safe. We'll see you next time.
Take care, everyone. Have a great afternoon. Bye.
Bye.